Ladies and gentlemen, fellow scholars from Halle, Frankfurt, Zurich, Washington, Minnesota, New York, Göttingen, Gießen, St. Louis, Tunis, Beirut, and so forth. Warsaw, sorry. It could have been expected neither cognitively, let alone normatively, that such a fascinating constellation of research approaches would be brought together to cast more light on the dark realm of the normative. How to deal with the shocking fact, for some at least, still shocking fact of contingency, namely that normative orders, normative systems, legal orders, their cultural canvas or structural fundaments can be quite different from expectations, each in their own way. This issue concerns legal anthropologists seeking to precisely describe norm-oriented behavior in widely different cultures. Philosophers armed with the discursive belief in reason, some at least, cultural sociologists observing normative plurality, and naturally also historians investigating historically valid normativity in any given period. The implicit assumptions they carry with them, their observational concepts and their what is it? What I'm looking for at the moment. There is some kind of irritation, and there must be a reason for it. I have to ask my psychoanalyst what has been going on, and this was not a prepared joke, I can assure you. So discursive belief in reason, cultural sociologists observing normative plurality, and so forth. The implicit assumptions they carry with them, their observational concepts and theoretical conjectures along the normative world, which we shall collectively sum up through the conference as the normative complex, and study in its sub-regimes of legal cultures, validity cultures, and normativities, seem to point to the fact that despite coming from different disciplines and subscribing to different paradigmatic commitments, there is no escaping this mysterious règne normatif. To get us started on this topic, I wish to illustrate this neo-normative paradigm, if you allow, if you will, with the help of an example that might at first seem far-fetched, the example of an extreme exceptional event, namely World War I. But before going into details, I have to pass a message by Raja Sakrani, program director of our center, who is obliged to stay away from this conference for medical reasons. She gave me the task to pass the following message. Chers amis et collègues, chers invités, c'est avec un profond regret que je me vois obligé de ne pas être parmi vous aujourd'hui et demain. J'aurais tellement voulu vous recevoir, vous écouter et échanger avec vous tous au sujet d'un thème aussi complexe et aussi fascinant que celui de ce colloque. Soyez les bienvenus au Käte Hamburger Center Recht als Kultur et je vous souhaite à toutes et à tous un bon colloque fertile en échange et en réflexion. Voilà. Alors c'est assez pour vous, l'applause pour vous. Introduction. Despite its great volume, literature remembering World War I all but completely leaves out one angle, namely interpreting the war as the starting point of normative upheaval. Legal paradoxes of injustice, the legal suspension of law as well as the source producing its own kind of validity, encompassing all parts and orders of life. From military criminal law to the restriction of fundamental rights, acts of censorship and limitations of property rights, over moral regulation of fashion, to the propagation of codes of honor in a society that, despite its wish for uniform experiences, was divided, as we know, into estates, classes, and parties. I would like to propose the term validity culture in a state of emergency, Geltungskultur des Ausnahmezustands, to describe this mode of validity. It's a mode that lays claim to the unlimited authority to suspend and replace existing normative orders in their entirety. A comparative history of the validity of the normative complex in World War I orders is still outstanding. Our center is planning a joint Franco-German conference on this topic with Sciences Po next spring, entitled La Grande Guerre et le Droit. Nevertheless, a first image emerges in which the protagonists of a doctrine on values and norms and of the sociology of normative orders, such as Weber and Durkheim, Simmel, and several others, including Emil Lask, this gentleman on the other side, were involved as tragic participants in the normative collapse brought on by the supposedly Great War, as it was called by all the participants of that horrible event. The maintenance of normative order by way of military, criminal law, and mechanisms of external control of actions is my first point. Alberto Monticone conducted an impressive study on the Italian military justice system. No comparable research has been conducted on the Prussian military justice system, as the files kept in Potsdam went up in flames in 1945. Thus, to analyze legal discourse in which a specific image of war was developed and imposed, we are left with the decisions handed down by the Reichsmilitärstrafgericht, the Imperial Military Penal Court. Following procedural logic, they contain more legal questions than questions of fact, thus initially making them seem less helpful for the purpose of our analysis. But however, in fact, the character of the legal dogmatic questions asked actually reveals the specific nature of this both frightful and frightening instance of social control. Max Weber was spared taking on the problematic duty of military criminal law. Judge Heinrich Dietz suggested lawyers take on in a widely circulated outline of military criminal law. The letter's work offers an unconcealed description of the spirit of military criminal law. He who sees the typical image of order and rules of inner clarity and justice in armored power also knows about the importance of its law. If the army, according to Dietz, is the people at arms and its purpose is war, then military criminal law is concerned with ordering that which, in the tradition of Hobbes, might appear as absence of order in the highest degree, war as a lender of order. The reference point for order is not the universal community of peoples, however, but the particular nation. The military legal order, which Moltke described as the soul of the army, that's the law, penal law, the military legal order, is then declared to be the legal interest not just of the army, but of the nation. According to this construction, any attack on this ordering of disorder represents a threat to national unity. The decisions of the Reichsmilitärgericht reveal the legal dogmatic consequences of this identification of people, military and nation. Paragraph 85 of the Militärstrafgesetzbuch penalizes abandonment of one's post without permission during battle, and this is a very interesting point. The decision of the Erste Militärstrafsenat dated 30 April 1915 dealt with how to interpret this offense. What from the meaning of the penal provision would seem to be a temporarily limiting condition is extended to a permanent state due to the specific nature of the new form of war. The decision reasoning reads, in order for the element of during battle within the meaning of this paragraph, it is not necessary that the offender is among those fighting. Neither it is necessary that the unit to which the offender belongs immediately participate in the battle. So what it means in the end is, if we take, this is the Militärstrafgesetzbuch just by representation, abandonment of one's post without permission during battle, that is the point. And so if during this specific war there is no moment when there is no battle, because it is a permanent battle, it means that everybody is under permanent control of military severest law one could imagine. And this is the logic, and that is why it's so important to see how this notion, this concept of during battle is interpreted. It means that all behavior is under this heading. So the trench war brought this kind of control as a legal consequence of the specific structure of this war. I would like to mention a further example that conveys a wrong impression of impermissible or risky adventurism to the present-day reader of Jünger's Stahlgewitter. When Jünger mentions, so this, of course, you might remember the famous picture by Otto Dix, Der Schützengraben, and this is the young Ernst Jünger decorated, as I call this nice picture. When Jünger mentions plundering, for instance, the middle-class property owner's hair stands on end in shock. The decision dated 16 October 1916 resolves this error. It reads, the right to spoils is a sovereign right to which in principle only movable enemy state property is subject. To this extent, the national collective scope of military criminal law, as stated above, also applies to the other. However, the judgment limits this principle in its continuation. In exceptional cases, the private property of persons attached to the enemy state can also be declared spoils. Naturally, one wonders what might constitute such an exceptional case, and is surprised to find out that, absent general provisions, a person belonging to the class of soldier is permitted to collect spoils insofar as his superior officer has granted him permission. The decisiveness of the military commander thus wins over the supposed universalism of individual ownership of property. If highly decorated Ernst Jünger suggests pillaging, then, following this decision by the Reichsmilitärgericht, he has the highest judicial permission to do so. As the letters from Italian prisoners of war cited at the outset show, the status of prisoners of war became part of daily life in military criminal law early on. A judgment from 6 March 1917 astounds with its grotesque guideline: the Kaiser is the superior of the prisoners of war. The legal background to this statement is a penal lacuna found in the offense of lèse-majesté, as it unfortunately only applied to Germans. To protect the Kaisers, honor against attacks from the prisoners of war, the court resorted to the venturesome construction of applying military criminal law to prisoners of war and qualifying the Kaiser as their military superior. That's crazy. Finally, a key experience of World War I, which, as I shall show, can be found within and beyond the trenches, namely the heroic experience of community, is also regarded as an aggravating element in penal law. Any misdeed irritating the spirit of discipline in front of the assembled unit is penalized, even when dealing with prisoners of war. Discipline as a legal interest of the nation is affected when, as stated in paragraph 12, besides the superior and the individuals involved, at least 3 other persons belonging to the soldier class gathered for the purpose of military duty were present. The image of war found in military criminal law can be condensed into the following statement. The normative image of military criminal law is the ordering of anarchical chaos, the total and permanent surveillance of the individual deduced from the nature of the trenches, which, against the backdrop of the image of a total community in the form of the assembled unit, even has the effect of aggravating penalties in case of any attack against military authority. Let me quote one episodical debate that seems to be rather revealing for the normative spirit of the time and the Geltungskultur of exception. What to do with those criminals who lost their right to be part of the military order, who, by losing their Ehrenrechte, were expelled from the right to die for their country? Paragraph 31 of the German Penal Code stipulated the permanent loss of the Heeresfähigkeit for those criminals who were sentenced to Zuchthaus penitentiary. Instead of appealing to necessities of the war, Dr. Kormann argues in the Deutsche Juristenzeitung as follows for an inclusion of inhabitants of the penitentiary. Man beachte immer wieder, dass sich solche Wirkungen oft aus fernen Jahren geltend machen in einem Ringen um Sein oder Nichtsein des deutschen Volkes, während unsere Feinde auf allen Fronten mit gewaltiger zahlenmäßiger Übermacht drohen und sich erniedrigen, mit immer erneuten farbigen Horden weit jenseits unserer Begriffe von Ehre und Ehrlosigkeit Seite an Seite gegen unser Kulturvolk zu kämpfen. Zitat Ende. Let us recapitulate the normative perversity of this justification to better the penal law against its wording. Honor should be attributed to the legally honorless former prisoners because they, as Germans, value more than those soldiers humiliated to farbige Horden that the French and British army had recruited from their colonies. I come to another point of the normative complex. Regulating everyday fashion in the homeland, morals and hypermorals. The example of fashion demonstrates how the normative habitus of the other was perceived. German fashion magazines portrayed French fashion as a caricature of itself, as an instruction manual on how to dress for coquette. For instance, it was widely held view that the appearance and morals of the German woman had been spoiled by French fashion and that her natural beauty had been defaced by French cosmetics. Such a degeneration, it was held, was inevitable so long as the German woman did not free herself from the land of coquette. This war of the spirits, der Kampf der Geister, was continued in the mutual denial of the other's moral foundation of sociality. As Iron Günther summed up, stocky German women only made fools of themselves attempting to replicate what was so natural to the thin and elegant women of France, Chic would always be unattainable to plump German Gretchens. One should hasten to add that contemporary evidence reveals the opposite to be true. There was a high sensitivity toward the moral requirements demanded of a social institution that is frivolous by nature. The task was to design the body line of women's fashion in such a way that the honor of the soldiers in the trenches would not be offended by provoking Drückeberger, as those not serving at the front line were called in Germany, to cast lascivious glances at the women working at the home front. Jewelry should likewise be truly appropriate to war. Material and shape should express the gravity of the situation. Works on daily life in World War I Paris reveal the following remarkable reflections on the phenomenon of war fashion. Writing in Revue Internationale de Sociologie, the rival outfit to Durkheim's Année Sociologique, led by René Worms, Lavardeur reasons that given the limited means in tough times of war, one should focus on the line in order to achieve the desired fashionable effect. On les chaussa de hautes bottes lacées à la russe en même temps. On écourtait les robes, sans doute pour que les années de guerre n'altèrent pas leur éblouissante jeunesse et pour qu'elles conservent plus longtemps l'illusion du printemps. Materials and shapes that smacked of military uniforms were criticized as bad taste. Real women, the moralizing commentator insisted, knew how to dress with elegant restraint and how to wear jewelry befitting the war. Elle ne porte pas de bijoux, seule la vogue de se fabriquer au front et doublement précieux fut extrême. Bagues, broches, croix en aluminium se multiplient et furent acceptés comme bijoux de guerre avec fierté. The validity culture of the state of emergency suspends and reduces the contingency of binding the unbinding. The paradoxes of fashion are reduced to what is permissible, practical and necessary, all in light of the exceptional situation that only allows fashionable exceptions to a limited extent. War society under censure, moral state of siege. The news preface to the classical work of Maurice Dreyfus lucidly summarizes the context we are interested in. Peu à peu, cette interdiction de prendre connaissance de l'évolution des événements va provoquer de nombreux abus de droit et de multiples moyens d'expression seront mis quasiment hors la loi. To put it in a paradoxical way, any infringement of the normative arrangement of communicative freedom, so to say, of the press and of private postal correspondence, is legitimate if it protects the morale of the troops. Jusqu'au ridicule, les censeurs vont s'appliquer à prohiber, prévenir, mettre à l'index tout ce qui aurait pu affaiblir la morale de l'arrière. This infringement affects the entire cultural life of society. Cela devait toucher aussi bien le théâtre que le music-hall, sans oublier le cinéma naissant. Both in France and in Germany, then society was under moral siege. Or, stated differently, censorship was no longer a mere element of disciplining or an element of the disciplinary society à la Foucault, but a mental state signifiant que le pouvoir légal n'était plus dans les mêmes mains. Democratic institutions changed their character and became, as Dreyfus put it, hostages of the censors. In these times of war, there was no worse crime than to want peace. That was the greatest crime. Such humanists therefore needed to be silenced. This mood that captured all of society even affected the socialists who once wished to believe in peace and now claimed that labor laws or social protection laws no longer existed, that all that remained was war. Il n'y a pas de droit ouvrier, plus de loi sociale, il n'y a que la guerre. From the myriad examples of where the census intruded, allow me to name but a few from the world of theatre. A piece already carrying the suspicious title L'Amant d'Annette is condemned to hell because it has the audacity of promising the amusement and immorality associated with vaudeville pièces. C'est l'histoire d'un mari à la fois jaloux et crédule qui confie la garde de sa femme à celui qui en est précisément l'amant. La pièce ne paraît pas devoir être visée, dit le censeur. On the other hand, musical comedy, Les Deux Aveugles, received a pass even though one of the authors was named Jacques Offenbach. According to the records from February 1915, a censor proclaimed in his defense, ce compositeur a toujours été beaucoup plus parisien qu'allemand. So, another question. The peculiar power of disciplinary society to control within the realm of the normative is thus unleashed. Le censeur se transforme en électron libre, jugeant selon ses propres critères, aggravant les lois qui régissent l'état de siège. In the validity culture of the state of emergency, the censor becomes the normalizing figure of moral repression. I come to my last point, the normative complex, the totalizing power of the validity culture of the state of emergency. Hereby, a double transmission is basically made. On the one hand, the likes of the master of the state of emergency, Carl Schmitt, still tried to cloak the illegal in a legal form. On the other hand, Agamben and those of similar persuasion investigated the history of the validity of the state of emergency and typologically linked it to the wellspring of charismatic read anti-legal rule per auctoritas in the sense of Weber. The latter, however, refers neither to actual nor to fictitious, let alone wanton state of emergency found in constitutional doctrine, but rather to a mode of the validity of law, morals, manners, convention, and ways of life, which we shall subsume under the overarching concept of the normative complex. This mode of validity lives off the pathos of the emergency or exception, which is juxtaposed to the banality of the normal. As an extrajudicial decider, it upholds the illusion of normative constitution in order to place the entirety of normative orders under the single premise of the validity of the extraordinary, in the case of which the decider on the suspension of normative orders takes on the guise of an impersonal institution, namely war, in order to propagate real life through deathly ritual vitalism, if one recalls the related text by Carl Schmitt on political theology and dictatorship. One can comprehend the closeness of the formulations, perhaps also to those of Agamben. The validity culture of the state of emergency is thus determined by the unlimited authorization to suspend the entirety of normative orders and to refocus them towards the extraordinary quality of war. Symbols, rituals, and organizations of validity maintained by commissioners, censors, and the agents of the state of exception, relieved of norms, are then all fixated on this singular source of validity that looms over the defunct history of validity. My final remarks. Nothing new philosophically. Emil Lusk's theory and experience of validity. I want to end with a few remarks on Emil Lusk, whom I mentioned earlier and who also is depicted on our flyers. No one has shaped the semantics of validity as much as he, perhaps except Mr. Vorländer. But also nobody has left so many open questions that he was unable to answer himself. After having worked tirelessly as a professor and even being of Jewish descent when he wanted to become a soldier, not even a junior officer, a simple soldier, and fell near his birthplace in 1915. On just one single occasion in the desolate trench did philosophical thoughts run through my head at all, he says, and writes to his academic teacher Heinrich Rickert in an unpublished letter dated the 3rd of March 1915. In return, however, his poetic powers were unleashed. We are in the Carpathians, cloaked deeper and deeper in snow, mountainous landscapes beyond comparison and crane-black and white-feathered forests. Das muss man vielleicht doch besser im Deutschen sagen. Wir sind in den Karpaten immer tiefer und tiefer in Schnee eingehüllt, unvergleichliche Gebirgslandschaften und kranigschwarz und weiß gefiederte Wälder. Der Philosoph. What, however, was his contribution to validity theory and the philosophical perspective on law? I would like to go into this further in the second panel. So that's a promise for the future. After we have acquainted ourselves with the concept, applications, and memorial functions of legal culture during the next panel, tomorrow we will then target the normative complex in a global world, where the multitude of normative orders is condensed into the concept of global legal pluralism on the one side and fragmentism on the other side, and simultaneously inquires into the producers of this normativity, the state, but also other agents of norms. From whence this normative power is to emerge, on which resources the force du droit draws, these questions point to further validity types, Geltungsarten, to use Emil Lusk's terms, that are located beyond the boundaries of law and are found in usages, customs, convention, fashion, and manners. And since discourse is unconceivable without some normative regulation, however, the epistemological value of the right to discourse and ethics and manners of discourse may be determined, I shall now give the floor to Assistant Director Nina Detloff, who will moderate the first panel as a jurist, as a comparatist, as a specialist in family law and European law, as member of the Commission to formulate the principle of European family law, and I could continue like this. Thank you very much for being with us, of course, and for making the next panel as lively as we want to have it, and we have it in general. If we are meeting at our House of the Legal Cultures, but for reasons of Brandschutzbestimmungen, as you know, who having the highest normativity, even much higher than constitutional law. Well, we agree on that, Professor Herding. We, for the moment, have not the right to use this place for occasions like this, and are very pleased that rather close to our usual place we are able to talk and chat and to discuss. I have only now one question to the speakers, to try to stay in time as I tried to do. I had just half an hour and it worked more or less. And then the same would be asked for the speakers, talking for 30 minutes and then having 15 minutes for discussion after each of the presentation. This is my proposal, because it gives the opportunity to react directly. Sometimes, if you just ask questions after a long list of speakers, then the last one, because our memory is very short, just remains the main focus of discussion, and this would be unjust. And we are in a context in the realm of normativity, and questions of justice play a certain role in that. So thank you very much for your attention.